everybody, welcome to Learn with Steph. This is one of the videos as part of our Lessons in Law series. The focus is on OCR A Level Law, but it will be useful to anybody studying law. If you like the videos, please do subscribe and press the like button at the bottom. This is our first lesson in the topic of the liability in negligence. There are 4 parts of this topic in the OCR A-level course. That is duty of care, breach of duty, damage, and you need to evaluate the topic and suggest reforms. It's worth noting that the damage is different from the compensatory damages that you may have learned during your study of remedies of tort. So first of all, let's look at negligence and what it means. It means carelessness, a failure to act or to do something that causes an injury or a damage to a person or their property. And in order to establish negligence in civil law, you need to establish 1, that there was a duty of care owed between the defendant and the claimant. The second thing to prove is that there had been a breach of that duty. And thirdly, that damages resulted from that breach. And all 3 things need to be established in order to prove negligence liability in civil law. So first of all, let's look at what duty of care is, the first element in negligence liability. And it's a phrase that we have in common language. We say a doctor owes a duty of care to their patients. But how do we automatically know that? You know that a teacher owes a duty of care to his or her students, and a driver, of course, owes a duty of care to all other road users. And this is common knowledge, but how do we know? What's the test? Well, there is actually no single test to establish duty of care in all situations. Sometimes it might be laid down that there's a duty of care owed in a statute. For instance, a driver owes a duty of care to all other road users is clearly laid down in Road Traffic Acts. Sometimes whether one person owes a duty of care to another is laid down in precedent. And you will have studied some of these when you looked at omissions in criminal law. So for instance, there might be a contractual duty of care owed as laid down in Pitwood, or there might be a duty of care owed due to efficient position as illustrated in Dyson. However, sometimes the situation that you might get in your exam will be an entirely new situation. So my advice will be, in your exam, you will need to recognise that there isn't a single test and that sometimes there's an obvious duty of care. And if there isn't, you'll need to go through the test that is used when it's a new situation. So if it's a new situation, the court will apply the Caparo Test. And please note the spelling of Caparo. It's 1P, 1R. And this test is a 3-stage test of foreseeability, proximity, and policy. We're going to look a little bit more detail into those 3 terms. However, the Caparo Test was originally laid down, or rather it came out of the very, very famous case that you've already studied, Donahue versus Stevenson, the snail in the ginger beer case. And this case, as you probably already know, was the start of the modern law of negligence. And in the Donahue versus Stevenson test, it laid down what became known as the neighbour test. And a very famous judge called Lord Atkin laid this down. And he stated that you must take reasonable care to avoid acts or omissions which could reasonably foresee would injure your neighbour, and your neighbour is someone you should hold into your contemplation. So basically, in this case, he laid down that a manufacturer owes a duty of care to their consumer to protect against acts or omissions that could do them harm. From this two-part test in Donoghue versus Stevenson, Caparo added an additional element. Now, I wouldn't bother knowing anything about the facts of the case of Caparo. Just learn the three-part test of foreseeability, proximity, and a policy test. And it's the policy test that Caparo added. So the three-part Caparo rules are: foreseeability, were the consequences reasonably foreseeable? Proximity, was there a close relationship between the defendant and the claimant? And then the policy test of fair, just and reasonable. The court will ask, is it fair, just and reasonable to impose a duty of care on this defendant in this situation? So firstly, let's look at the term foreseeability. Was the harm reasonably foreseeable, or were the consequences reasonably foreseeable? Now, this test is an objective test because we've got the word reasonably there, haven't we? So in other words, it doesn't matter whether or not the defendant foresaw the consequences, it's whether or not a reasonable person would foresee those consequences. The court asks not what the defendant foresaw, but what a reasonable person could have expected to have foreseen. A case illustrating this idea of reasonable foreseeability is Kent v Griffiths. In this case, an ambulance failed to arrive in time when it was called to deal with an asthma attack. The court held that it was reasonably foreseeable that a patient would get worse if an ambulance failed to arrive in time. So there was foreseeability in this case. The second care test is proximity. So the question is, was there closeness between the defendant and the claimant? And proximity means closeness, but it's judged in terms of space, time, or relationship. Now be careful, because just because somebody has a relationship such as their aunt or their nephew doesn't necessarily mean in the specific situation that there is a duty of care. So just be careful on that when you look at scenario questions. So this idea of proximity comes from the case Donoghue versus Stevenson that we have already looked at. And if you remember, Lord Atkins said that neighbours, or approximate relationship if you like, were people you should hold in your contemplation. So that idea of somebody you should think about whilst you are carrying out a particular activity. And a case that illustrates this idea is Boer versus Young. Notice it's Boer, not Bourne. And sometimes just people refer to this case as the fishwife case. I have no idea why. And basically what happened here was a pregnant woman was travelling on a tram, I believe, and she heard a crash, got off the tram and walked some distance to have a look at the crash. She later miscarried her child and claimed that it was a result of seeing the crash. Well, the courts decide in this instance that there was no proximity. She was not close, and this is because at the time of the crash, she wasn't even in the vision. She couldn't even see it, that she had to go out of her way to see it. Now, obviously, the people around the crash at the time, there would have been proximity. But for this particular lady, there was no proximity. There was no closeness. Okay, so that's foreseeability and proximity. The final test is the policy one of fair, just and reasonable. Would it be fair, just and reasonable to impose a duty of care on the defendant in this situation? And this is a very important test. It was the one that was added by Caparo, and it's a policy test. So in other words, the courts look at what's best for society. And if you like, the theory behind it is to stop too much litigation going to court, to stop the floodgates of litigation, as it's called. Okay, and there used to be certain situations where the courts wouldn't impose liability, perhaps on the Ministry of Defence for soldiers being injured or harmed in battle situations. That immunity has gone. There used to be immunity for barristers from negligence prosecution. That has now gone. The most recent one is it's often seen as it's not fair, just and reasonable to impose a duty of care on the police and rescue services. So we're just going to have a look at this idea briefly. So as I've said, the court looks at what's best for society as a whole, and the idea behind it is to prevent cases that are not the best for society to come to court. And quite often courts don't impose a duty of care when the police and rescue services are involved. If you think about why this might be, why it might open the floodgates of litigation to impose a duty of care on the police and rescue services. And I suppose the way to think about this is thinking about perhaps a firefighter who is putting out a fire in your home, and whilst they are putting the fire out, they damage equipment in their home. Perhaps they're spraying water in your living room and they ruin the electrical equipment that's in there. You can imagine that the courts would see that it would not be fair, just and reasonable to impose liability for the damage to property caused by water onto the firefighters as they are putting out a fire in your home. So we're looking at those sorts of situations here. And the case that illustrates this idea is the Yorkshire Ripper case of Hill v West Yorkshire Police, basically. And in this case, the victim of the Yorkshire Rippers, sorry, the mother of the last Yorkshire Rippers victim sued the police for negligence. She claimed that the police should have caught Peter Sutcliffe, the Yorkshire Ripper, before he had killed her daughter. And there was a lot of evidence that the police did not conduct the investigation into the Yorkshire Ripper well. There was a lot of evidence that they were careless, even incompetent, one could claim. However, the courts held that it would not be fair, just and reasonable to impose a duty of care on the police to catch an unknown criminal. And quite a lot of people used to think that this gave the police some sort of blanket immunity from negligence prosecution, or the police and rescue services. The case of Robinson, however, made it very clear that there was no such blanket immunity. Now, in this case, the police were trying to arrest a drug dealer, and they needed to arrest him in the street during the drug deal. But unfortunately, whilst they did, a bystander got injured. And basically, a good way to explain Robinson is use the word clarify. So this case clarified the Hill rule, if you like. So it stated that there was no blanket immunity, that public services could be liable in negligence when a positive act is negligently performed and that act causes harm. So doing something that is going to cause harm if the police do that negligently, they can be liable for negligence. And a case that illustrates this idea is Caparo versus Hampshire County Council. And in this case, the fire brigade were dealing with a fire and they accidentally turned the sprinklers off. So clearly there was more damage to the building because the sprinklers had been turned off. So the fire brigade did a positive act. They turned the sprinklers off. And the court held that it was fair, just and reasonable to impose a duty of care on the fire brigade's negligence because they created the additional danger. So basically, even though the courts are sometimes reluctant to impose a duty of care on police and rescue services, liability is imposed when the public authority creates the danger or harm, or does something to create the danger or harm, or that it has assumed responsibility for an individual's safety. So, for instance, when the police arrest somebody, they have a duty of care to that prisoner. So, duty of care consists of foreseeability, which is an objective test, proximity in terms of time, space, or relationship, and a policy test of fair, just, and reasonable. And when you're assessing the policy test, the thing to think about is what is best for society. So in your scenario that you discuss in your exam, you would want to say probably that it would be fair, just, and reasonable to impose a duty of care because it would not be to the detriment of society to do so. The next session will be on breach of duty. That brings us to the end of this lesson in law. I hope you enjoyed it. If you did, please like it and subscribe to find more videos. Bye.